Okay, I've seen the council has now arrived, so we'll plan to go ahead with this. Hereby call to order this special session of the Bloomington City Council. Please stand for the Pledge of Allegiance and remain standing for a moment of silence. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Well, this evening is somewhat of an unusual occurrence in a couple of ways. First of all, to the starting time. Secondly, the subject matter. And thirdly, because we thought that we had said goodbye to Alderman Hanson. But here he is again. I was kidding him that he was here just because he couldn't stand to stay away. He really missed the controversy and so on. But in actuality, legally, this is the old council convening to consider a question with regard to the new council. This special meeting has been called because of questions raised by citizens and aldermen alike regarding the eligibility of a member of this council, Judy Stearns, to be seated for an additional term as alderwoman representing the 4th Ward of Bloomington. The impetus for the many questions I've heard on this matter, and I think we've all heard, has been the Jackson case up in Chicago, Jackson versus Board of Election Commissioners of the City of Chicago, which was actually decided, the opinion was issued in February of this year by the Illinois Appellate Court. That case is coincidentally relevant in that it establishes that multiple homestead exemptions can constitute an underpayment of property taxes, which then constitutes a debt to a governmental unit like Bloomington that can bar eligibility to serve an elected office under state statute. And I'll let council explain that a little bit more if he chooses later. However, the Jackson case was centered on the eligibility for election. In that case, the candidate was denied the ability to be on the ballot because of a timely challenge to the oath that was given by the candidate when she filed for office. And this may be a process distinct from eligibility for seating. Now, Illinois law provides that this city council, this old, the last act of the old city council, can be the judge of such eligibility questions, although our decision is reviewable by the courts. In making our decision, we must focus on the exact criteria set out by the law. That is, has an alderman's debt to the city or a elected candidate's debt to the city been satisfied to the extent that she is now eligible to hold office? Has her underpayment that we all acknowledge occurred now been cured? Focusing on other issues, including general questions of ethics or payments due to other governmental bodies, in my understanding, are not relevant under the law. At this meeting, we will determine what action is currently appropriate. Do relevant and substantial questions remain, and do we need further legal guidance? Or do we need to conduct a full hearing on this matter? Or does a majority of this council believe that Ms. Stearns' recent payments have cured her underpayments and she should be seated without further delay? Now, to help us decide this evening, we will first hear from Corporation Counsel Todd Greenberg, and then from Ms. Stearns or her representative, and she has informed me that she prefers to have her representative speak in her stead. Both of these discussions, or presentations rather, will be limited to 5 minutes. the time will be devoted to council discussion and questions. Remember that this is not a formal hearing as to Ms. Stearns' eligibility, just a determination of whether such a hearing or further investigation is necessary. Also keep in mind that our time is limited because we must convene in regular session by 7:30, so please be concise. So with that, we'll now open with a 5-minute presentation from Corporate Counsel Greenberg.
I'm going to state my conclusions first, which is the way usually attorneys work, and then I'm going to give you my reasoning for it. I'm not aware of any factual or legal grounds which currently disqualifies Judy Stearns from taking the oath of office for alderman for the 4th Ward. And I'll give you my reasoning. 2 weeks ago, I became aware of what we've now all known as the Jackson case. The Jackson case involved an issue which, in identical terms, can be faced by a city council, although it's in 2 different points in time. In the Jackson case, a candidate for the City Council of Chicago had filed nomination papers. Shortly thereafter, someone filed an objection to that person's candidacy on the grounds that the candidate had multiple homestead exemptions in the city. And because of the undervaluation of the property taxes, according to this objector's opinion, that person was therefore in arrears to the City of Chicago on property taxes. Although the hearing officer and the Chicago Board of Elections and the trial court agreed that the candidate didn't have an arrearage, the appellate court surprised, I think, a lot of people by determining that the multiple homestead exemptions did cause an undervaluation in the payment of property taxes, which did cause an arrears in taxes to be owing to the City of Chicago. Now, I'm going to use the word snapshots a couple of times because there are 2 dates when snapshots are very important on arrears. One of them is the date a person files their papers for nomination. You can't undo that once the papers are filed. In the Jackson case, the court said, in accordance with prior case law, that since she wasn't eligible to be an alderman on the date she filed her nomination papers by reason of the tax arrearage, she wasn't eligible to be on the ballot and her name had to be stricken. The other snapshot that's important is whether a person is indebted to a city in taxes or other debts on the date of an oath of office, and that is where the City Council has the authority to determine that person's eligibility for office. I contacted the mayor as soon as I found out about the Jackson case. He and I both agreed that evening that it was fair to talk to Judy about this and to give her a heads up on it. She was very cooperative. Mike Ireland and Judy and myself worked to try to calculate any arrears based on the logic of the Jackson case. And we have, to the best of our ability, Mr. Ireland and I and Judy calculated those amounts, and she has paid those amounts. The other issue is the council is also given the authority to act as the judge of elections. However, in every case I've found where a city council has done so, they have used the same statutory guidelines as a court would if a challenge were filed after an election, which is, was there some error or fraud in the way the votes were counted, or was there some irregularity in a particular precinct in the way that election was conducted? I haven't found any situation in which a city council tried to go beyond those particular issues in the statute where you were given the ability to be the judge of an election, where the council's decision was upheld. And specifically, because I thought this would be quite important, I have not found any cases where a city council was able to successfully keep someone from assuming office on the grounds that even though their name was on the ballot and they won more votes than anybody else, that their name shouldn't have been on the ballot and therefore they shouldn't be allowed to take the oath of office. So those are the 2 factual and legal issues which you would have the ability to address tonight. I've given you my opinion that as near as any of us can calculate, there is currently no tax arrearage or indebtedness. part of Judy Stearns, nor am I aware of anything which indicates any irregularity in the way the votes were counted or the way the election was conducted in any of the precincts of the 4th Ward a month ago. So that's, given the 5 minutes, that's what I have to say. In case there are any questions, I can answer them.
We can use the remaining time in the 5 minutes to ask questions right now, but I think we will hold our other questions at the end of the 5 minutes. Yeah. Okay. Well, why don't we hold questions until after Judy's counsel has spoken. Mercer, would you please introduce yourself?
Sure. My name is Mercer Turner. I've been an attorney here in Bloomington for 33 years. My office is at 202 North Prospect Road in Bloomington, Illinois. It's a pleasure to be back here again. It's been several years since I've been here. There was a time in earlier life when I was actually here at every council meeting when I had to watch a certain council member who had a proclivity to pull consent agenda items for one of my clients and to vote against them and argue against them, encourage others to do so, and I just simply had to be here to make sure something silly didn't happen. So there was a time when I was a regular attendee here. Anytime I've been here, it's always been for real estate development, and as you all know, that's the way it is. So, Mr. Mayor, I can't possibly do it in 5 minutes, but I'll rush through this. I need to tell you that on no less than 9 occasions have I asked to know what the procedure was this evening, and I request on 5 written occasions that I meet to discuss this with you and with the city manager and with Todd, so I know what the procedure is. Giving me 5 minutes to do this is insufficient. I'll do the best I can, but I believe I'll be going over 5 minutes, and to the extent that I do, let me apologize in advance. Mr. Mayor, you're dead wrong in your explanation of the Jackson case. I didn't have I know you've got a very fine education. I didn't have the privilege of some private schooling. I'm just a state school graduate. But both you and Todd Greenberg have skimmed over the fact that Cook County, during the relevant time, had issued a billing to that candidate related to trying to collect the tax due to the error of the multiple homestead exemptions. That is the controlling fact, and that controls a proper legal decision as it pertains to Judy Stearns. It is undisputed, and I'm confused as to why it is that I have to be saying this, because it's been well known by the city for a number of days, but it's undisputed that the supervisor of assessments of McLean County has no interest in attempting to have ever collected anything from anybody in the history of the county as it relates to errors that occur for homestead exemptions. They have much bigger issues to contend with, and our supervisor of assessments is an extraordinary public servant who creates millions of dollars of tax revenue for the taxing bodies that levy under our real estate tax bills. There is one event in particular which distinguishes him from assessors in the entire state of Illinois, and that is when he implemented the instant assessment of new properties. And he creates taxes for periods of time by implementing instant assessment that would be lost permanently. And this has created millions and millions of dollars of tax revenue for all the taxing bodies that participate in our tax bills. I would encourage you to allow him to continue that fine service and to not suggest that he get bogged down in looking at every owner-occupied premises and all the new owner-occupied premises and all the premises on farms that are owner-occupied, and keep track of obituaries and everything that would be required in order to determine whether owner occupancy is appropriate on every property in McLean County. The law is very clear, and it is stated in the first exhibit that I have given you, the very first tab, and I have highlighted it. that the assessor, the supervisor of assessments, has the complete jurisdiction to issue the general homestead exemption. His decision is not subject to appeal. It can't go to the Illinois Property Tax Appeal Board, and it can't go to court. He has the total authority to do it. There is no written form that exists to apply for it. Again, in the law, in that first tab, it says the assessor can use a number of different ways to determine whether or not it's proper, practically any way, including personally inspecting the property. In McLean County, if you go into the supervisor of assessment's office and ask for a form for the homestead exemption, they're gonna tell you there isn't one. If you're entitled to one, ask for it. And if they find out you're not entitled, they will immediately eliminate it. And if they issue one in error, it'll stay there until somebody points out that it's inappropriate. And as soon as they find out it's inappropriate, they will eliminate it. The assessor's office stands tall, and the assessment team that consists of the city assessors and all the rural township assessors and the great people in the supervisor of assessment's office are very fierce in upholding our taxing system and making it fair and equitable for all parties. As a result,
Sir, you're at your 5 minutes. You need to be far more concise and try to sum up. I'll give you a few extra seconds here.
but let me say that none of the assessments that Judy Stearns had were the result of any requests that she made or anything that she did to encourage them, other than she asked that there be one on the apartment that she lived in, and she asked it to get transferred. It got transferred, and the one that existed on the original apartment she lived in was not eliminated. Clearly in this case, the existence of the assessments were the result of assessor error, and I think it's a abuse of judgment on your part to try to make a claim out of an assessor error into an election error. Let me also indicate that
10 seconds.
that I have read the city code, and on May 1st, Judy became the elected representative based on the last election. I've attached it in this packet. Your code provides that on May 1st, she took office. It also provides that the oath is administered by her signing it under oath. Thank you.
Thank you. I apologize on the limitation, but we do have, need some time for discussion here, and there may be an opportunity to embellish this.
Mayor, I wish to respectfully recuse myself, and if there are questions, I will be sitting with Mercer.
Okay, the alderwoman has recused herself and has removed herself from the council seating area. Okay, I guess we'll open it up to the council for discussion or questions. The goal for this evening is to decide what we do in terms of swearing in the alderwoman this evening, or if we don't do that, what procedure do we follow after that? Anybody? Jennifer?
Mayor, I have questions that I've gathered based on my conversations with constituents in my ward and residents throughout the city. I have several questions, so at some point, if I stepped over my time, please indicate that, and I'll simply stop. My first questions are about our remedy to this situation, and I'd like to understand, as it was stated by Mr. Greenberg, that Mike Ireland, Todd Greenberg, and Judy Stearns calculated or accounted for with the arrears, the amounts, and as you stated, Mr. Greenberg, as near as we can calculate that there was no arrearage. I'd like to understand what the precedent is for that kind of remedy, how we know that that remedy, in fact, we reached an accurate number, that in fact, that was a legal remedy on behalf of the city, and that in fact, since we don't normally get into the business of collecting those taxes, how we in fact know that that in fact was within the legal grounds of the city and in fact accurate.
Todd, why don't you start?
Well, I think we're aware from news reports that the county collector was not going to accept back taxes. I haven't had a chance in the 2 weeks available to see whether that's accurate. I know there is a distinction between an ability to collect omitted taxes, which can be done, and the ability to collect under-assessed taxes, which I've found just in a couple of legal journals does say that the counties don't do that. Regarding the way Mr. Ireland and I calculate the arrearage, we looked at the Bloomington properties that were owned by Ms. Stearns, because the statute of limitations on back taxes is 20 years. Now at that time I didn't look at the distinction between omitted taxes or under-assessed taxes. That's as far back as we went, trying to use as best we could the records of the county that are online, and also the records of the assessor's office. We calculated the amount that would have been assessed had there been no homestead exemptions. We took that, divided by 100, because property values are, taxes are assessed per $100 of EAV, and then we multiplied it by the city's tax rates, both with the exemption and without it, and then we just added it up. In short, that's how we did it. I don't know at this point of any error that we made, and I don't know that I can go beyond that. Now, regarding the ability of the city to accept payment instead of going through the county clerk, the Jackson case itself mentioned that in collecting taxes, the county essentially, and this is the court's comparison, is more in the steps of a bill collector. The actual debt is owed to the taxing entity, so I don't know of any situation where if a person paid the creditor rather than paying it to the bill collector, that anybody could have any grounds of saying that that debt is still owed because they didn't pay the bill collector, that they paid the creditor directly.
Did you want to follow up on that, Trevor?
Sure. So with regard, I guess I have a question then to follow up with regard to the situation where the city is in a position, based on the Jackson case, where in fact you felt it necessary to pursue the arrears. But in fact, the county is not willing to cooperate in that case. Who holds the county accountable for that?
Well, as I said very briefly, there is a distinction, and Mercer may know more than I do, but there is a distinction between collecting undervalued taxes and collecting omitted taxes. But at this point, usually courts in ruling in terms of equity, in terms of fairness, they say the courts will regard as done what should be done. And in here, the debt was owed to the city. In my opinion, the fair thing to do was that if we could calculate what that debt was, to allow the person to go ahead and pay it directly to the city.
Let's let Mercer get 2 cents in here, and again, please keep it concise.
Very quickly, it isn't that the county isn't cooperating. The county has no legal right to. The county's recourse on correcting this would have been to issue certificates of error. I provided the certificates of error here and intended to explain it to you, but just for the recent tax bills that have been issued, there's 3 pages already of certificates of error. And the time to assess a certificate of error for what's being discussed relative to Judy Stearns is long past. There is no remedy. In general, the law in the United States has tried to been developed so that for every wrong there's a remedy. In this case, there has been no wrong, and so there is no remedy that exists. And the county, it's not that they're not cooperating, they have no right to do that. And in fact, historically, they've never done it, and they don't intend to do it. There's no reason to do it. It's ridiculous.
Mercer, I have a question. We've heard, a number of us have heard from many citizens that I think probably don't necessarily understand all the legal principles and so on here, and certainly not the case law. But they seem to approach this from a matter of equity as opposed to a matter of law. And that is, what I hear is Judy had too many exemptions regardless of what reason. And whether it's purposeful, accidental, whatever. And the question is, how can we make this right? Because had the mistake not been made, there would have been higher taxes assessed on Judy. And how do we make this right as a matter of equity?
Mr. Mayor, again, let me apologize for my humble state school degree, but this has nothing to do with equity. The key element in the election statute says debt or tax. A debt or tax has no remote relationship to equity. There has to be established a debt. And a debt is something that's legally collectible before it's invoked. Now, if you want to know how to make it right from an ethical point of view as opposed to a legal point of view, Judy has made the payments that Todd has described, and I reviewed those, and I can tell you that they overcalculated what would have been owed, and she's paid a little bit more than what she should have. And in addition to that, she and I have made the county issue certificates of error for the next year. She requested that the county do so after the avalanche of media attention. And then they sent me the results, and I provided it to you, and guess what? They omitted one of the 3 properties, so I called Hannah. I said, Hannah, for heaven's sakes, get the 3rd one eliminated too. And so now those 3 properties will never have a homestead exemption in the future. They've been eliminated. She has paid the tax on that. She's paid a tax estimate. In a case where a tax bill cannot be created, or a debt cannot be created, it's strictly an ethical showing on her behalf of good faith. And Mr. Mayor, despite the fact that this doesn't involve equity, I think Judy has shown equity, and she's got clean hands and a good heart, and some of the concepts that are applied in equity and trying to keep good faith with what her obligations are. Thank you.
Well, Mercer, but had there not been mistakes, and first of all, do you agree that having 4 homestead exemption was a mistake, not necessarily committed by Ms. Stearns, but a mistake somewhere along the line?
Absolutely, positively.
Okay.
And Mr. Mayor, that's one of the things I tried to get accomplished here. I wanted to say that Judy was going to admit to the whole factual underpinnings here of what occurred, so that you'd have that as a base to work upon. Absolutely, she does. You didn't have to ask me that because she volunteered to admit it, and I've begged the city to accept that admission, and I've done it in writing several times in the past 2 days.
Okay, but now that's established. Had it been done correctly, would Judy have paid higher taxes over the years?
She would have, unless she knew that because when she purchased foreclosure property, she was purchasing it well below then existing fair market values. One of the illustrations I show you is that she probably has actually overpaid her taxes by thousands of dollars because she didn't know that tax relief was available when you purchase a property under the then existing assessment, which happened at least twice in this case.
But that's a separate process, but I think it's established that on the basis of the exemptions, Judy did pay less. Now, whether or not that has a bearing on her being seated or not is another issue.
Yes, Mr. Mayor, let me tell you that she did pay less because of the existence of the issues, and now she has paid more. Thank you.
Jennifer?
I have a question. I understand there's the Jackson case, Todd, is what you've used as a legal basis for a lot of your argument, but I understand that there's another case out there, the Sincus case from 2008. Perhaps, is that something that you've considered?
Yes, very much so. The Sincus case basically stands for the proposition that in terms of challenges on a candidacy's eligibility, the Sincus case was the one that basically said you take a snapshot of what the situation was on the date the nomination papers were filed, because in Sincus, it was a situation where there was an ordinance violation judgment that hadn't been paid on the date the nomination papers were filed. It was paid after the nomination papers were filed, but the court said no. You look at what the situation is on the date the nomination papers were filed. At that point, he had an indebtedness to the city that had not been paid. The certification that is included in the nomination papers is that I am qualified to serve as alderman, not I will be. And that was there was the argument by the candidate in the Sincus case. He said, well, as long as I take care of it before it's time to get sworn in, it's not a problem. The appellate court said no. The issue is, were you eligible to be an alderman on the date you filed your nomination papers? You weren't, because you had an unpaid indebtedness to the city. That's what the Sincus case said. Yes.
So to follow up, can you please specify how that's different than what we're talking about this evening?
Two different snapshot dates. The election has come and gone. Whether there could have been an objection filed to Ms. Stearns' candidacy is now academic. It didn't happen. The issue now is whether she has taken care of the indebtedness prior to the next snapshot date, which is the date that she is scheduled to be sworn into office. And in my opinion, she has. Jennifer.
I stated I had a lot of questions, so I'm just going to keep asking them until someone else wants to ask a question, and I will stop, as I said earlier. So, if in the Sincus case, did they, in fact, get into this two-snapshot process that you're talking about?
No, because his name was removed from the ballot, I presume that he wasn't elected.
Jennifer, John has a question. If you want to yield the floor for a minute, we can come back to you if you want.
Thank you.
John?
Well, mine isn't so much a question as more of a statement and hopefully a fairness to how this thing should move forward from my perspective. I'm sure there's people sitting out in the audience that feel that I shouldn't even have a perspective at this point, but you know, I've rated over the years the number of constituent concerns and the times they've contacted me and or made casual comments on the street, and this rates up there as one of the top. And I really was kind of getting disconnected from the city about a week ago, so I've kind of come into this thing, I guess, full steam ahead. I am willing to make or suggest a motion this evening on what I think would be fair as far as how to move this forward. I'm not questioning whether Judy Stearns was elected to the office of Ward 4. Judy was elected. I think it's very important that this council shows fairness to Judy, you know, the constituents of the city of Bloomington, and also fairness to the integrity of the city council of Bloomington. As I've been in my business, as I've walked down the sidewalk in my neighborhood, as I've taken calls from people today, constituents seem to use the word seriousness and how this impacts the integrity of the city council in Bloomington. And I take that very serious, the integrity of the city council. So that's what I'm hearing. That's what I feel is very important in this matter. And what I would like to see, and I think, again, it's in fairness to Alderman Stearns, as it is to the other folks that are sitting around this table and the constituents of the city of Bloomington, is to, which we've done in several cases, at least in my time on the council, seek some outside counsel, bring those results back to the city council, and at that point, there can be a decision on whether the council would feel that we need to move forward with some form of hearing, or at that point, it's going to be very, and I'll be watching closely, it's going to be very important that whatever the results of those findings are, that it's portrayed through the media, which is most people's avenue for information, that they understand completely this process that has transpired. So, I want to make a motion right now, but if there's any more comments, but I am willing to make a motion in that direction. Stephen?
Well, John, I appreciate you coming out of almost semi-retirement and coming into the council tonight to, to talk and discuss with us. I appreciate, what you have to say, but also, there has been information disseminated to you and also along the other council members about, how the whole process works and how it all transpired and what happened and how the assessments, the assessment for the homestead exemption wasn't pulled off like it was supposed to be, okay, which caused a lot of this problem. She hasn't got a bill that she had. She's paid her debt according to the city of Bloomington as far as what she owes. There is no outstanding problems with the election that I'm aware of that's ever brought up. And, to hold it over and say, well, we have to have somebody else look at it and find out what's going on. Well, we already know what's going on. The law states unless there's something serious that transpired here, that you have to see her. It's that simple. The law is pretty specific on what it says. Yes, we're the judge, but the question is, what are we judging? It's either the debt or the corruption in the election process, and I don't see either one of them. So if we continue and push this over and let somebody look at it, who would that person be, or who would that group be, and what is it they're going to look at? Because there's only two things to look at: the debt and what the corruption is of the election itself. And neither one of those, there's not a debt, and I haven't seen any corruption unless somebody can bring that forward. Nobody's presented a bill that says this is how much you owe from the county. So, in all due respect, I appreciate what you have to say, but the law requires us to follow the fact, make a decision, and move forward. Thank you.
I guess, Stephen, my response to that, I have been receiving all the information. I have not been taken off the email trail of the city servers. I'm still the acting alderman. I know Rob Fazzini's sitting here, and he'd love to get up here real quick, but I am still the acting alderman, and certainly was not expecting to have to even address this issue. I guess in response to your comment about, in simple terms, put it to bed, what I'm hearing is that people want to understand the process, and that's why I think it's fair if we take and look at it from outside counsel, and they say there has been nothing, whether it's technicality, legality, there's been nothing in that process that doesn't warrant Alderwoman Stearns serving the office. It's a dead issue at that point. But I think it's fair, and again, you know the way that the story goes. We can vote up or we can vote down. I'm just gonna, and I will make the motion that we go and seek outside counsel and bring it back as soon as possible to determine whether there's anything that has been missed. And again, Todd, I should have started with no disrespect to you or Mercer, either one, for your professional abilities, but that we seek in a very timely manner some outside counsel and bring it back to this body and determine at that time if it warrants further review.
I'll second.
Okay, it's been moved and seconded that we seek outside counsel. I would ask, and that's going to close off discussion from outside counsel because there's a motion. I'm going to ask, though, a couple of questions. Number one, who would select the outside counsel? How would that be done? And number two, I think we should have a date. This cannot just continue to roll on. I think we should put some pressure on to have a date where we get an answer back and make a determination on this.
Well, I guess the time frame would be up to the council. I mean, I think it's in fairness to Alderwoman Stearns, and I think it's in fairness to the constituents in this body that we get it done in as timely a manner as possible. I mean, I have confidence that between legal, yourself, and David, that you can come up with some names or a name or of a firm that does this kind of work, and select a firm that would take this case and look at it.
Okay, so you wanna leave it up? Yeah, I think we should include Todd in that group also.
Yeah, I said legal.
Okay, all right. We ask the audience to refrain from loud conversation, please. Okay, is there further discussion? Karen?
I just want to add my support to the sentiments that John's expressed. I have been
Of course you do.
really quite surprised at the overwhelming number of questions that people have had, and it doesn't have, it focuses more on who we are as a council and what our values are, and trying to understand what the requirements are for us and for the citizens of Bloomington. And I think a lot of misunderstanding about whether we're setting a special precedent and treating one person differently from basically everybody else in Bloomington. And I really think that
That's
if
what
we
you're doing
have
now.
that arm's length analysis of what has happened here and a second look at the law, that there will be an awful lot more belief in who we are as a body. And that is with no aspersions to Judy Stearns or anybody else. I just think that as a process, it's an important process for us.
Okay, Stephen, real quickly here, because we're up against it.
Well, I know we're breaking new ground here because no council I'm aware of have ever done this. We are breaking new ground and setting new precedents, so I'm not really sure how that's gonna work out in the long run. I was kind of concerned who was gonna be picked, and what is it, like a legal firm? Is it like a legal firm specifying in campaigns and taxes? I mean, and if they do make a recommendation, then do we take that recommendation, or we just listen to what the information they have and read it, and then make a decision where we feel like we can seat somebody who has 600 votes was winner of the election, even though this stuff was in the paper, and they understood, the voters did, they understood that there was a homestead exemption situation, and they still voted in her office, put her in office. And like I said, I don't see any reason why. I understand, the people need to listen. I mean, the voters. I only had one phone call today. It was a past alderman who served here on the council and asked me about it. And other than that, I've had one guy at work. I was at work before I went home early to study for this stuff today. And other than that, I really haven't had any phone calls or emails. So I'm just saying that, yes, it's important that the public knows, but I think we can educate them on what homestead exemptions are and how they got on that record and how they didn't get off that record without calling in, an army of legal experts to tell us what we already know, that the law says you either put her in or you throw her out, depending on the law.
Okay, I'm going to go ahead and try to summarize this. We've heard today that our corporation council feels that Judy Stearns is eligible to be seated, and her council obviously feels she's eligible to be seated. However, there's been a lot of questions tonight among this council as to understanding why and helping us make our own judgment as to whether or not we should take these opinions. And we are in fact the deciders. You asked, will the outside legal counsel make the decision? Absolutely not. They just give us guidance. This council needs to take the responsibility and authority to make that decision. We've also heard from a lot of concerned citizens who have said this is an important question, and I think it's important that we not just gloss it over. However, it can't take too long. I'm really concerned that this would drag on. I would like to make this decision as soon as possible, hopefully even at the next meeting. So if this motion passes, Todd, David, I think we need to work very hard and diligently to try to get something done right away. So with that, I would like to call for a vote on the motion. That's acceptable. Yes vote would be to support the hiring of outside counsel. So please take the roll, Madam Clerk.
Aye.
Aye.
No.
Yes.
Alderman Front,
Yes.
Alderman Sage,
Yes.
Alderman McDay,
Yes.
Alderman Hanson.
Aye.
Okay, the motion carries. To close out, I would like to have a motion concerning swearing in of the remaining candidates, instructing the clerk.
Mayor, before you second it, I'd like to speak to that.
I'm sorry?
I'd like to speak to that before it gets seconded. I've been days and asking this to be explained to me so I can arrange an appropriate time to speak, and I've requested more than 5 minutes. And I will to speak to the question of swearing in.
Okay, well,
I'll be 1 minute or less.
the council want to open this up again, or do we want to just?
I'm not interested in opening up.
Why stop the railroad?
Come on.
Come
I'd like to make a motion that we suspend the rules and let him explain what the swearing in process means to this council.
Thank you.
That's a proper motion. Is there a second? Okay, this requires a 2/3 majority. Let's take a roll call on this.
Aye.
Alderman Villalobos.
Aye.
Alderman Purcell,
Yes.
Alderman Schmidt,
Yes.
Alderman Front,
Yes.
Alderman Sage,
Yes.
Alderman McDay. Yes. Alderman Hanson.
Okay, Mercer, that gives me the authority to let you do this.
Thank you. 1 minute, no longer. It's tab 5. Your code already has her installed. She became the alderman based on the election, May 1, your home rule district. Nobody read your municipal code. I understand there were outside municipal councils polled on this. I wonder if any of them have ever read the Bloomington Municipal Code. May 1, she became in office, and then the last page of the handout is what the oath of office is. It is simply signing the form under oath. That form is available in statute, and if you don't allow her to sign it, she's gonna make a protected signing of it and file it with the city clerk, because she should take the oath of office before she serves. She in fact should have taken it before the earlier meeting today. That's all I had to say, thank you.
And Todd, I know that this has been discussed. You want to give your
Correct.
opinion?
I totally disagree with Mr. Turner. A person does not take office until they have been administered the oath of office. There is also a separate situation in the Illinois statute which states that a person remains in office until their successor is qualified. So, just so the general populace understands, Ms. Stearns is still going to participate as a member of the Bloomington City Council unless the City Council were to decide that for some reason she is unqualified by statute to enter into a new term of office. She will be holding over. It is, the City Council has not made a decision tonight on whether she is in fact disqualified. There is no vacancy in the office she carries over. The reason there was no hearing today is because we did not have the time. It was not possible.
And we don't have the rules.
We do not have the rules. I've stated in the memo, which is now a public record, that there is procedural due process which must be afforded, which includes the right to counsel, the right to put forward evidence on one's own behalf, the ability to cross-examine any witnesses. There has been no decision yet by the City Council which disqualifies Ms. Stearns from entering office. As I understand the motion, the issue is to ask for a second opinion, and at that point, there would be a decision whether or not to decide not to have any more proceedings on the council's clear statutory authority to be the judge of qualifications, or to go ahead and, if there is more inquiry required, to then have a hearing. That has not happened at this point, and that's why I didn't have the authority to agree to a hearing. The mayor did not have the authority to agree to a hearing, and the city manager didn't either. That is the prerogative of the City Council.
Okay, given that, I believe that we need to instruct the clerk as to whom should be sworn in. we basically have outside counsel, but I would like to see a motion as to who should be sworn in tonight. Todd, do we need to do that? Or was that pardon me?
Yes.
Okay. Would someone be willing to make a motion as to instructing the clerk whom should be sworn in, and given compatibility with the last motion, I assume that's not going to include Alderwoman Stearns.
Since it's my understanding that the council has voted to hire outside counsel to review the eligibility of Ms. Stearns to be sworn in, and therefore that her swearing in would be delayed until, in fact, we receive the findings from that agreement, I would make a motion that the aldermen for wards 2, 6, and 8 be sworn in this evening.
Is there a second?
I'll second that.
Okay, again, let's take a roll call vote on this so it's on record. A yes vote is to swear in the 3 aldermen and not Ms. Stearns. Sure.
Excuse me, I'm very confused about this. Am I supposed to vote on my own swearing in? I find this very odd.
Yeah. Whole situation's
Yeah.
So does the citizens.
Don't know, I
And I
mean.
get the same question, Karen. I mean, I'm a little bit uncomfortable voting on my own.
Well, Todd, I mean, we have to have an authority.
No quorum.
Judy in, so tell us what you think we should do.
Swear her in.
Earlier, I was asked a question over whether this is a legal conflict of interest, which is prohibited by law in voting on this issue. The type of prohibited conflicts of interest that impose criminal penalties if an alderman votes on it are contracts for the purchase of goods or services. Beyond that, it is strictly a matter of ethics, whether one feels that it is, inappropriate or has the appearance of impropriety. So that is up to the individual alderman.
They both questioned it.
Mayor, may I please?
Sure.
I'm willing to amend my motion to separate the 3 wards if that would meet the needs of those that have concern about
Yeah,
this.
rig it any way you want to.
We need to have, next time we have an outburst like that, we're going to have you escorted from the room. Okay, Jennifer, are you withdrawing your previous motion?
Well, I'm just looking to see if that's in fact what is desired.
I think that would work if that makes people feel more.
Okay,
course.
I would like to remove my motion, and then I would like to enter a motion to support the swearing in of the alderman in Ward 2 this evening.
Okay, Bernie, is that okay to withdraw?
Yes.
Does anyone wish to second the swearing in of Alderman Ward 2?
I'll second it.
Okay, with that, let's take a quick vote. A yes is to swear in the alderman for Ward 2.
Alderman Anderson.
Aye.
Alderman Longworth.
Aye.
Alderman Purcell.
Absent.
Alderman Schmidt. Alderman Front.
Yes.
Alderman Sage.
I'm gonna abstain from that vote.
Okay.
Alderman McDade.
Yes.
Alderman Hanson.
Aye. Okay, we need another motion.
I'd like to make a motion that we swear in the alderman from Ward 6 this evening.
Second.
Okay, a yes vote is to swear in the alderman of Ward 6. Please take a roll call vote.
Alderman Anderson.
Aye.
Alderman Longworth.
Aye.
Alderman Purcell.
Absent.
Alderman Schmidt.
I abstain.
Alderman Front.
Yes.
Alderman Sage.
Yes.
Alderman McDade.
Yes.
Alderman Hanson.
Aye. Would someone like to make the motion on, I guess, Ward 8?
I'd like to make a motion to quickly swear in Alderman from Ward 8.
Second that.
Okay, again, yes vote is to swear in the alderman from Ward 8.
Alderman Anderson.
Aye.
Alderman Illinois.
Aye.
Alderman Purcell.
Absent.
Alderman Schmidt.
Yes.
Alderman Front.
Yes.
Alderman Sage.
Yes.
Alderman McDade.
Yes.
Alderman Hanson.
Aye.
Okay, and then Todd, do we need to do anything with Ward 4? Or is this sufficient? We've never done this before, so I don't kind of need your guys.
As I said earlier, Ms. Stearns will continue to serve as an alderman for Ward 4 until the council either decides not to proceed any longer and go ahead and authorize her swearing in, or if it determines there's still questions after the opinion from outside counsel is received, then it would need to schedule a time for a hearing, which procedures that I said earlier about being able to present evidence, about being able to question and cross-examine it, have assistance of counsel would be important.
Okay, but do we need any other action here to delay this one?
No.
Okay. Then that being the case, is there any other discussion here, or do we adjourn this special meeting? Is there a motion to adjourn? Is there a second? All in favor? Opposed? Okay, we're adjourned. We'll come back into session in just a moment here. We'll go into Tracy, we're going to be outside.
The goal was to the oath of office outside at the flag. So in about a couple minutes, people will hear for the oath and we can go outside.